In foreclosure, they want to see the cases move, and they've given us a roadmap with set deadlines in order to make cases move.
The Weekly Friedman, your source for the most essential information in the default industry, with your host, Adam Friedman.
About a year ago, Florida foreclosure timelines changed significantly. Joining me today is Friedman Vartolo partner Laura Noyes to provide some insight on how those changes impacted the industry. So as I understand it, a year ago, something big happened in Florida that really impacted timelines. You want to walk us through what the change was?
Sure. So effective January 1st, 2025, the Supreme Court has amended the Florida Rules of Civil Procedure. This was huge for our community as it has impacted all sorts of cases, foreclosure and non-foreclosure, huge complex cases, anything that really goes through state court.
In the default industry, this was interpreted as a big change to Florida foreclosure. But it sounds like what you're saying is this was much bigger. This was Florida everywhere or in many places. Is that right?
Yes, everyone was impacted by this.
So did it work? It's been a year. Has this made a big impact specifically in Florida foreclosures?
So I think when it first came out, there was a whole lot of panic. These were strict deadlines. We were really worried that the judges were going to be actively monitoring this. But I think what we've seen in the last year is these changes were created to create efficiency and to create momentum in our civil cases. In foreclosure, they want to see the cases move, and they've given us a roadmap with set deadlines in order to make cases move. And I think it's had some positive, it's had some negatives, but I think it's also really given firms the ability to stand out and make themselves really strong advocates for their clients as long as they can build out proper systems and tracking.
So let's say I am an investor or servicer with a big Florida portfolio. I think the key headline here would be a year ago, things changed. Florida foreclosures got faster. It sounds great. Were there any negatives?
No, I think ultimately we have seen the cases move. The judges want to see these dockets get cleared. They have their own, they're being managed themselves too. They have deadlines that they have to meet. They have to clear their dockets. So I think ultimately coming in where you're seeing people get impacted negatively are the ones that are just reacting to deadlines and not proactively monitoring deadlines and working their cases. If you go radio silent, the judges are seeing that you are not diligently working your cases. And it's a red flag. You're highlighting yourself for the judges to come and point out your cases. And clients don't want to see that.
I'm not a servicer, I'm not an investor. But I think what's important to recognize is there's less places to hide. We all know there are firms in the industry that will hide behind different court problems or judge problems. And it kind of sounds like in Florida, for the most part, most of those are now gone and things move. And your counsel should really be active and timelines should be more aggressive than they used to be. Is that fair to say?
Oh, absolutely. I think there is opportunity to move, especially volume portfolios, quickly here. And if you go silent, using the excuse that you're waiting for a trial date doesn't exist anymore because on day one, you're getting some sort of proposed trial date. It's really going to change the standard in these cases.
Laura, I appreciate it. This is obviously a big topic and something many of our clients are closely monitoring and wanting more information on. So I appreciate you hopping on.
Thanks so much. This is great. Happy to talk about it further.
Thank you for joining Laura Noyes and I in the Weekly Friedman, your source for the most essential information in the default industry. Thanks for tuning in and looking forward to seeing you next time.